Hi everyone. Today we'll be going through another business law examples. Please note this video is only for tutoring purposes. It's not for use for in actual real world events or cases. So it's only just for studying purpose. And yeah, I hope you enjoy it. So today I want to go through the example of contract law. And basically, so we have an example here where we have an expert in business law, and she enters the contract with you to provide two professional presentations for your accounting firm. Your contract requires each of her presentations to be 1 hour in length, and also requires the expert to provide printout copies for her PowerPoint slides for your staff. It's particularly important that the experts' presentations are 1 hour long, since this is a requirement of the Australian Accountants Association for staff professional development activities, and the expert is aware of this. But then, due to a family emergency, the expert needs to leave for the first presentation in 15 minutes early. Her presentation only goes for 45 minutes, so it doesn't count for the staff accreditation. In addition, she didn't provide printouts for her PowerPoint slides, as her local printing business was unexpectedly closed. You are disappointed that the expert has breached two of the different terms of the contract, and you wonder whether you can terminate the contract ahead of the second presentation. So overall, the question is whether you could terminate the contract for breach in performance according to law of contract, and then explain why or why not in relation to both the contract terms has been breached. Refer to the relevant legal cases to support your analysis and ensure that you fully explain the legal position you have taken. So to tackle this question, we will answer in such a way. So a breach in performance usually involves not only a complete and conscious repudiation of the whole contract, but rather a breach of certain obligations under the contract. A breach in actual performance by one party entitles the other party to terminate the contract in two situations: if the acts or omissions by the defaulting party are such as to show an intention to repudiate the whole contract or to carry out in a manner of inconsistent with the obligations under it, or if there has been a breach of some essential obligations under the contract. In our main issue, we're addressing the question whether the expert has breached in performance, and whether the contract terms are conditions or warranties which the expert have breached, and hence the plaintiff yourself can terminate the contract in advance due to this breach. In the case of Associated Newspapers versus Banks, the plaintiff argued the terms of the contract, i.e. displaying the comic on front page, was not a condition but a warranty, classifying it as a non-essential term. However, the court has concluded that the term was a condition, and therefore the defendant was entitled to terminate the contract due to a breach of condition. Similarly, as Sherlin and the plaintiff have, as the expert and yourself have agreed the presentations to be 1 hour length, the court will consider this agreed term as a condition, as the expert has an obligation to perform a presentation to be 1 hour in length, where the duration of the presentation matters. It is also considered an essential and important term, as described in the passage, that it is particularly important presentations are 1 hour long, since this is a requirement of the Australian Accountants Association, and the expert is aware of this. However, the principles of contract law, breach of condition gives rise to a right to treat the contract as at an end or terminate the contract. Hence, Sherlin's breach of condition in the contractual term of presentation duration allows plaintiff to terminate the contract in advance. The next question is whether the failure to provide printouts is a breach of condition or a breach of warranty. In the case of Bettini versus Jai, the requirement to be in London without fail 6 days before rehearsals was classified as a warranty, after going to the root matter, so that a failure to perform it would render the performance of the rest of the contract by the plaintiff a thing different from what the defendant has stipulated for. In our case, if we were to go into the roots of the matter, if there were no printouts provided by Sherlin, it would not have mattered because as the presentations can still be presented with 1 hour duration, which is most likely to be classified as a condition by the courts as per previous as I mentioned before. Under the contract law principles, a warranty is a subsidiary to the main purpose of the contract to present for 1 hour long, so that this breach confers merely to a right to sue for damages and not to terminate the contract. If the printout terms is not a condition by warranty, then the express breach of warranty can only be used for a right for a plaintiff to sue for damages and not used as a basis to terminate the contract. So overall, on the basis of the expert's breach of condition for not providing the presentation of duration of 1 hour long, where both parties knew the importance of this term upon entering the contract, the plaintiff yourself can terminate the contract in advance before its end of date. Additionally, the breach of warranty for the experts being unable to provide the printouts allow yourself to sue for damages caused from the warranty term not carried out as per the contract. So hopefully you understand that. And if you have any questions, please let me know. Otherwise, yeah, see you next time.